So I'm Frank Bailey, and I am the president of Pioneer Public Interest Law Center. Welcome to the second year of Reasonable Minds Can Differ, a look at some of the key cases in the U.S. Supreme Court in this 2023-2024 term. Just a couple of words about Pioneer, and that's the end of that, right? So and we'll put them up on the slides. Where's Avonlea so I can see her? Here she is. You're advancing? All right, okay. So just a couple of words about what we have been doing. We've been operating since June 2022. That's about 18 months. And I want to highlight a little bit of the progress that we've had. The first slide is highlighting our work in the educational choice area, a case involving the rights of virtual school kids in Massachusetts, permanent virtual school attendees, to play sports on their hometown teams. They were, after 2022, they were told they couldn't play anymore, and so we felt that was inappropriate, it was bad for these kids, and we brought a lawsuit both in federal court and in state court, and I'm delighted to tell you that after that work, and we worked with the law firm of Sullivan and Worcester on that case, we had an excellent result. The kids are out there playing once again. So that was a very important case for us, and we're delighted to report that. The next slide focuses on our work in the economic freedom and fairness area. We've been working with Greater Boston Legal Services. Todd Kaplan, my co-counsel, is here. And in that case, it's way too complicated to get too deeply into it, but I will say this, that's what it is. We represented a Worcester homeowner who had about $220,000 in equity in her home. She lost that equity even though she owed only a little bit in taxes under the way Massachusetts law worked. The Supreme Court last term outlawed that conduct, which is taking all of a person's equity when they owe just a small amount in taxes. We were able to restore her equity back to her, and I call that generational wealth. And we'll take that case any day, and we are continuing to work on this on a more on the basis where we hope to change the law in Massachusetts. It has to change, right? Tyler says, Supreme Court said, that statute's unconstitutional. So now we're continuing to work on it. And I want to shout out to Morgan Lewis, who has been working with us on that case. And finally, I'll mention on government transparency issues, Pioneer Institute, we represented in that case against the MBTA. They had worked out a settlement in a union contract, but remarkably didn't reveal that contract. So we couldn't see the settlement, we couldn't see the contract, and we felt the public should have a chance, especially where they're $22 billion is going to be required to get the system up to where it ought to be. We were successful in getting the information, clawing it from the MBTA. So on government transparency, we're busy. Those are just three examples, and I'll move on. Those are our three areas of greatest interest, though. So we call this Reasonable Minds Can Differ. Why do we do that? Because our two law professors, who I'll introduce very quickly in just a moment, may see things differently. Last year, they mostly saw things the same way. And at the end of the night, by the way, I haven't told them this, we're going to look at what they said last year and see how right or wrong they were. Yeah, they may want to leave early. So anyway, they did pretty well, actually. So we have our professors, Jessica Silby and Gary Lawson, who are at Boston University School of Law, and the school is very fortunate to have them. I could go on for a very long time with their bios, but I won't do that because in the materials you will see a QR code And we're going to post these materials. I don't expect you to use it now, but when you want to figure out who they are and what they know, go to our materials, use the QR code, it'll take you to their full bio. But what their bios will not tell you is how cherished they are by their students. I have spoken to many, I've had interns who have worked for them or been in their classes. I hear that Gary spends a lot of time out having coffee, with the students as they, crowd around him. And you don't have to do that to be successful, but they do. And that's not in the bios. So I want to mention that. I know that from, it's a little bit of hearsay, just a little bit of hearsay, because I haven't witnessed it. But so next are materials. Again, when you get onto our website, you're going to see these slides. Those QR codes are going to take you to materials we have prepared for each of the cases that are going to be talked about tonight. The next slide, we have materials on the actual cases from last year. If you want to find out how they turned out, you're going to be able to get that by going to that page. So we may talk a little about those cases. We probably won't because we won't have time. I have to say one thing, though. The Supreme Court got one case entirely wrong last year, and I know that because I wrote the underlying opinion, and I was reversed. And I now think that Neil Gorsuch is the smartest judge in the planet because he dissented in that case and said Bailey had it right. So anyway, as far as questions are concerned, you have a pad. You can write down a question as you think of it tonight. We will collect those, so Professors Silby and Lawson are going to take us through the cases, and then we'll roll back to questions. You can ask them anything about any of the matters that they talk about today, and we can also, if you have something else you want to ask, fire away, right? This is a chance to do that. Okay, so thank you. I want to thank them so much for doing this. This is not,
don't clap yet.
This is, I know that they don't teach this, right? They don't teach this. They teach con law, which, is not, those are the principles that they're prepared to teach. They are not teaching these current cases, so they had to spend a lot of time to get ready for tonight. So. And we've been working out really hard questions for the last week, so we'll see how much they know. Okay. Anyway, here we go.
Right. Okay, so thanks everybody. We're happy to be here again for the second year in a row. So I just want to say, Gary is one of the foremost administrative law scholars in the country, so he knows a lot about some of these cases we're talking about. I, however, know less. But yes, we planned very hard. So the way we're going to do it is we're going to run through the cases. One of us is going to set up the case and then make the argument for one side, and we'll say which side that is, and then the other person is going to make the argument for the other side. It's going to be roughly about 14 or 15 minutes per case. Some of them are going to be a little bit longer. Some of them are going to be a little bit shorter because of the nature of the arguments. Do hold your questions for the end. We assigned each other these positions. We're being advocates for the debates, for the idea of debate. As we were talking through these cases, we agreed that these are hard cases. We could make the arguments for the other side as well. So this is more of an advocacy exercise than anything else. I want to point to our wonderful student, Ben Wishney-Edwards over there, say hello, who helped us squib many of these cases. Could not have done it without our fabulous students. All mistakes are mine, I should say, and not his at all. So I think with that, Gary is going to do the first case, which is Loper Bright Enterprises versus Raymondo.
Well, also with a companion case, Relentless Inc. versus Department of Commerce, two cases presenting the same statute. And I just want to elaborate on one thing that Jessica said. We did have a hard time figuring out who was going to take which side. Part of that, I think, is because of the way these cases were framed and argued by the parties and by the justices. I think both of us would have framed them and argued them differently, but we're taking the cases as we find them and working with that. All right, what's going on in these two cases? Well, if you ever find yourself in a forest with knights who say knee, you're probably going to want some herring. The thing is, you can't just, wow, tough crowd. Monty Python and the Holy Grail. Look it up. Herring, knights who say knee, tallest tree in the forest. Okay. But you can't just go out into the North Atlantic and catch a bunch of herring because you have to comply with federal fishery management plans. Those are required by statute. Now, the content of the fishery management plans comes from regional councils set up, which then propose their plans to the National Marine Fisheries Service, operating under the Department of Commerce, hence Relentless versus Department of Commerce. And the statute says that those plans have to address 15 different aspects of fishing. So there's a lot of stuff out there that fishermen have to comply with. Well, how is anybody going to determine whether any random herring fishing boat is complying with this 15-part plan? Well, the answer is you send out observers on the boats. So whenever the herring fisher boats go out into the Atlantic, there's going to be an observer on board. That is provided by statute. In 2020, the agency decided that it didn't have enough funding to be able to afford to put observers on the number of boats that it wanted to have observers on. It didn't need observers on 100% of the boats, but 50% would be good. But it didn't have enough money to pay for them, so its solution was to adopt a rule that requires the fishing boats to pay for the observers at a cost of something more than $700 a day. Think about what that totes up to over the course of a year. Some of the fishermen say that's 20% of their income that goes to observers. So the fishing company sued, saying that the agency had no authority to make them, they have authority to make them go out with observers. No one's questioning that. They questioned whether the agency had authority to make the boats pay for the federal observers that were going to go check compliance with the fishing plans. And as a matter of just pure statutory interpretation, from the standpoint of an administrative law nerd, it's actually a really interesting question of statutory interpretation. On the one hand, you have a very, very open-ended statute that simply says that the the fishing management plans may, quote, require that one or more observers be carried on board a vessel of the United States engaged in fishing for species that are subject to the plan for the purpose of collecting data necessary for the conservation and management of the fishery. That's what it says. What's an observer? Glad I asked. The term observer means any person required or authorized to be carried on a vessel for conservation and management purposes by regulations or permits under this chapter. Well, say the challenging fisheries, that certainly says they can require observers. Where does it say that they can make us pay for them? To which the agency responds, well, if we required you to go out on the ocean with foghorns, you wouldn't come saying, well, the government has to pay for the foghorns. Of course you'd have to pay for your foghorns. Why aren't the observers just like foghorns? To which the fishermen reply, well, this isn't really like foghorns. This is like making taxpayers pay for IRS auditors who are doing their audit. Surely you would need specific statutory authorization for that. And oh, by the way, here's 3 times in the statute where Congress specifically authorized the agency to make fish boats pay for the observers. Once it's foreigners, a couple other times it's special boats, but even there they capped the amount that they could make you pay to about 1/10 of what the agency is charging here. To which the agency responds, well, those are just specialized circumstances. None of that affects the generalized authority we have under the provision that says we can require observers, and then the circle continues, right? So as a matter of just pure statutory interpretation, it's a really interesting puzzle. Neither of the courts in this case, the DC Circuit or the First Circuit, actually answered that question. Right? They didn't ask what's the right answer to that tricky question of statutory interpretation. Instead, they asked, pursuant to existing doctrine, Are the fishermen just obviously, clearly right about what the statute means? And if they aren't, is the agency's position in the ballpark? That's the so-called Chevron doctrine. And I say so-called. I'm not going to get into this. I will in questions if you want. It's named after a 1984 Supreme Court decision that absolutely said nothing remotely resembling what the modern Chevron doctrine actually says. It just doesn't. Okay. The Supreme Court didn't even realize there was something called the Chevron doctrine until the early 1990s. Okay. Anyway, what that doctrine says is when an agency, under certain preconditions that everybody agrees are satisfied here, interprets a federal statute, court's supposed to ask not what's the right answer, but is there an obviously right answer? And if there isn't an obviously right answer, did the agency give it the old college try? And using that standard, both lower courts said it's not an obvious answer, so of course the agency's position is right. And the Supreme Court is being asked here to tell the lower courts, do something different. Don't ask those kinds of questions. Now, in one sense, I'm going to be arguing, I guess, that the Supreme Court should indeed tell the lower courts, don't use this so-called Chevron thing, figure out the right answer. I have to say, as a matter of first principles, I don't think I would be making that case because I just don't think the Supreme Court can tell lower courts how to decide cases. They can reverse them. The court doesn't like the way they decided it, but I don't think the Supreme Court can issue a press release saying, oh, by the way, this is how we think you should interpret statutes, or for that matter, interpret the Constitution. But nobody's arguing that. Nobody's arguing that question of power. It's assumed that if the Supreme Court says this is the right way to do it, that the lower courts are supposed to fall in line. Okay. Well, if that's all true, why would lower courts have to fall in line? Well, there are three basic problems with the Chevron doctrine as I've described it. It asks the wrong question. It gives the wrong answer to the wrong question that it asks, and it looks for the answer in the wrong place. Okay, start with the wrong question. Question with any statutory interpretation question is, what does the freaking statute mean? And the Chevron doctrine tells courts, don't ask that. And it's fairly easy to see why that's the wrong question. If the case comes up and there's no agency interpretation, what's the court going to do? It's going to ask, what's the best answer to the question of statutory meaning? Why should that possibly change simply because one of the parties to the case is a federal agency? If you can figure out what the right answer is when the agency isn't speaking, you can jolly well figure out the right answer when the agency is. So that's the wrong question. Wrong answer. If you are going to ask something other than what's the best answer, why would the default be that the government wins rather than the government loses? I mean, if this was a criminal case, after all, the traditional rule of lenity would say if the statute is unclear, the government loses. Why? Simply because this is a civil versus criminal case. Should we go from a rule of lenity to a rule of tyranny? I mean, if you aren't going to have the even Steven, why not have the rule of lenity across the board here so that the tie goes to the citizen? This actually came up in the oral argument where Justice Kagan said, what happens when the law runs out? Doesn't that mean the government wins? And then in the Loper-Bright case, former Solicitor General Paul Clement, arguing for Loper-Bright, said, I actually have the quotation here, no, in that case you should have, quote, a thumb on the scale on the side of the citizen. Why not? Third problem. They're digging in the wrong place. And this is also not an argument I would make as a matter of first principles. For the same reason that I don't think the Supreme Court can tell lower courts how to decide cases, I don't think Congress can tell any federal courts how to decide cases. But nobody's arguing that. As a matter of doctrine, it's well accepted that Congress can specify norms that courts have to follow for how to decide cases, such as reviewing factual findings for substantial evidence rather than whatever the right answer is. Well, the argument is back in 1946, Congress passed a statute, the Administrative Procedure Act, And one of the sections of that statute contained a whole bunch of instructions to federal courts about how to review agency decisions. And some of those prescribed deferential standards of review. For factual findings in certain kinds of proceedings, just ask if there's substantial evidence. For sort of residual agency actions, including fact findings in other proceedings, were they arbitrary, capricious, and abuse of discretion, or otherwise not in accordance with law? Pretty deferential stuff. When it came to statutes, what the administrative procedure said is the same thing it said with respect to the Constitution. Interpret the Constitution and the statutes. Well, if in 1946 Congress gave that instruction, by what authority do federal courts deviate from it? And instead of figuring out what the statute means, figure out whether the agency's interpretation of the statute is in the ballpark. And that, I think, is a nutshell of why the Chevron doctrine is and should be not long for this world.
Okay. So the stakes in this case are very high, as Gary has intimated. The Biden administration contends that overturning Chevron would be a convulsive shock to the legal system. So think about all the agencies: healthcare, finance, environmental pollutant, all the administrative agencies that are relied upon to carry out federal law through their own interpretations. That's what's at stake. Chevron has been cited over 18,000 times by lower courts. It's a doctrine with significant reliance, and that's because it addresses this inevitable question, which is, what do you do when a statute is either silent or ambiguous and an agency has to apply it faithfully? Petitioners characterize, Gary didn't say this, but the petitioners characterize this as a question of agency usurpation of power. That's what Paul Clement said. Of courts abdicating their proper role to interpret and apply constitutional law. That is what Gary said. And at bottom, a problem of agency capture. That's really what's going on here. I would characterize the Chevron case in a different way, or this case about Chevron in a different way, as the embodiment of what I think and what Chevron was trying to do, an ideal constitutional sharing of interpretive authority over law. So he told you a story, I'm going to tell you a story. We all know the black letter doctrine that courts interpret statutes. That's what we know, and that's because of Marbury versus Madison. But Marbury versus Madison was not a case about judicial supremacy. It was a case about constitutional supremacy. It was a case, does anybody remember the case? We remember what it stood for. It's a case about the Midnight Judges, 1801 Judiciary Act, and John Adams put all these judges in right before Thomas Jefferson was about to take office. Jefferson did not want to appoint Adams judges, and some of those commissions did not get delivered. That was Mr. Marbury's commission. And Jefferson withheld the commission, not because he thought he could ignore a congressional law. Well, he did think he could ignore a congressional law. But famously, that case said, "We are a government of laws, not of men." Jefferson nonetheless won that case, not because the Judiciary Act, because he was allowed to refuse to follow it, but because it was held to be unconstitutional, inconsistent with Article 3, Section 2, Clause 2, by expanding original jurisdiction of the Supreme Court. Congress can't just change that jurisdiction, the Constitution, by any ordinary legislation. Why am I telling you about Marbury? I'm telling you about Marbury because I think the case challenging Chevron is a return to these first principles, challenging judicial supremacy and elevating constitutional supremacy. The court gets to say what the law is, that is true, but Marbury is a case about the Constitution controlling, not the court controlling. It's a case about the Constitution controlling Congress, and it's about the law controlling presidents. But who controls the court? The establishment of judicial review to say what the law is came with this huge hole in this theory, because if nothing controls the court, and the court interprets both the Constitution and congressional statutes, each of which constrain Article 1 and Article 2 power, we have a hierarchy among the co-equal branches of government, not co-equal branches. And so I come back to this case, instead of conceiving of Chevron as wrong when it was decided, egregiously wrong, which is what Paul Clement said, impermissibly transferring Article 1 and Article 3 power to Article 2 agencies, I see it as an instantiation of what has always been and should continue to be the ideal, which is that branches of government, in fact, share interpretive power. And I think Chevron is actually a companion to Marbury. It's a corrective to read that case as instantiating judicial supremacy, which it does not, when in fact there is no such thing. So retaining Chevron, I think retaining Chevron where courts defer to agencies in certain cases where Congress has left that ambiguity for the agency to resolve is precisely the kind of collaboration we would expect from co-equal branches of government. So Chevron approved the notion that Congress, when left ambiguous in a statute or silent as ambiguous, for implementation of the agency. Think about OSHA, think about FERPA, think about the EPA. Understanding, Congress did this with the background understanding that that agency would resolve first and foremost those questions. And they desired the agency, not the courts, to fill that gap. We learned as recently, and we should cite some cases, so I'll cite some cases. Learned as recently as 2013 from the city of Arlington that even when a court finds a statute ambiguous, the agency's interpretation shall be sustained under Chevron. That was this court. Chevron does not apply unless the agency has used sufficiently formal procedures to resolve the matter entrusted to the judgment. So there are safeguards. That's U.S. versus Meade, 2001. In discerning whether Congress has spoken directly to the question, a reviewing court must apply the traditional tools of statutory interpretation. That's INS versus St. Cyr in 2001. All of this is to say that Chevron is not some freewheeling, give-it-all-up transfer of power from the federal government to the executive branch. It is and has become a considered and carefully crafted arrangement, sharing arrangement between courts, Congress, and the executive at a time when our national development and agencies play a much more substantial and important role in our complex society, to be sure. So the idea that courts somehow are better at filling the ambiguity, that's the argument here, better at filling the ambiguity in a statute than an executive, that's folly. And I think it smells of judicial supremacy as opposed to the appropriate allocation of power. Courts, and especially Supreme Court justices, know very little about the details that explain and justify the complicated laws that Congress passes and agencies administer. During oral argument, Elena Kagan was talking about the new AI Act that was going to be passed. Can you imagine those justices filling in the gaps on artificial intelligence? Congress passes these laws with the structure of government in mind, in view of agency expertise, and the changing winds of politics. One of the arguments was being made that there's all this flip-flop. Get a new administration, you get a new rule. And that, there's no reliance on that. But that's a feature. It's not a bug of power sharing in democracy. Knowing that gaps are inevitable, Congress can rely on democracy and the accountability of agencies through the executive to apply the rule in the most grounded way. For the court to do that usurps the power of the people. Petitioner complained of flip-flopping agencies every 4 to 8 years, but what about all the different opinions that the courts are going to issue? What about all those different interpretations that are going to happen? It's the whole point of Chevron is for stability. What the court really means that says, don't worry about that. We interpret the law. They don't actually mean that all those courts are going to be interpreting it all the way. What they really mean is they are going to issue the final policy decision. That is a usurpation of power and judicial supremacy, which has no place in our democracy. Okay, at bottom, petitioners' arguments rest on the fiction that there are clear distinctions between statutory silence, statutory ambiguity, and interpretation. These lines are fuzzy. That's why lawyers have jobs. And because they are fuzzy, we need a rule. Chevron has been a very good rule, a rule that strikes the right balance and has a long-standing tradition, well before Chevron came on the scene. So courts, they're still going to interpret the law. They've got to determine whether Congress has addressed the issue at the center of the dispute and whether the agency's interpretation falls within the zone that Congress has left open. For courts to ask for more power, I think, is asking a lot. And I think they should have more humility in the face of the other branches. Next case.
So,
When's
yeah.
that case going to be argued?
It was
It's already
argued.
argued.
You can listen to the oral arguments
You're right.
online.
Striking.
If you go,
When's it going to be decided?
Oh, yeah.
that's a hard one. But
Last day of the term.
June 29th.
All right.
let me just ask this: can people hear?
A little louder.
Okay.
It's
All
a
right.
problem. These are not amplifying tonight. That's a problem. So
Okay.
we'll do our
to know.
best. So all
The
right.
next case is Moody versus NetChoice. At issue in this case are two state laws, a Florida law and a Texas law, that would regulate large social media companies like Facebook and X, which was formerly known as Twitter. And the idea is that these laws were meant to control how these sites moderated their content. They were enacted in 2021 in response to legislators' belief that the companies were restricting posts of certain users, particularly those with conservative views. So NetChoice is a trade organization of media companies, and it filed suit contending that these state laws, which required platforms like Facebook and Twitter to host users on their site and to refrain from editorial discretion as a form of compelled speech that violates the platform's First Amendment rights. So these laws, Texas and Florida, only apply to platforms with at least 100 million monthly users or 100 million in annual revenue. So that would be Facebook, YouTube, X, Instagram, Etsy, and Pinterest. It would not apply to sites like Parler, Gab, or Truth Social, for example. So what do the state's laws say? They prevent these companies from moderating or editing or deleting posts of journalists or candidates for public office. Requires notification of content moderation standards, consistency of treatment of users on the platform, although it doesn't define that term, and requires the platforms to disclose and explain their reasoning for moderating posts. The 11th Circuit facially invalidated Florida's law under the First Amendment, and the 5th Circuit upheld a similar Texas law. So the courts will hear argument in this case at the end of February. I'm going to argue that the 11th Circuit was right to strike down this law as unconstitutional, and Gary's going to take the other position. Okay, so let's just start with the obvious about platforms. All platforms moderate content, and we're glad that they do. They have terms of service that we've agreed to when we use the platforms, violations of which get us kicked off or restricted. So when we follow someone on Facebook or YouTube, for example, our feeds get curated by algorithms that are constantly in flux, responsive to a whole host of factors. It could be how many clicks we've used, what time of day it is, whether we're repeat players, for example, how big the data packets are at any moment. Websites are constantly removing and reprioritizing posts. To say that they can't do that is to turn them into something else entirely. So the First Amendment doctrine, states are saying that they pass these laws to uphold the First Amendment. They say, and the First Amendment doctrine, though, that prevents these platforms, which are private entities, from disseminating speech, from editing their content according to terms of service, would send the internet into some form of chaos more than it is now. What it would be doing is dumbing down the platforms to a free-for-all, which is not the way to promote free speech in any realistic way. But the most obvious point, I think, is when you look at these laws, they're content-based, and they target editorial judgments of the platforms. Content-based laws are presumptively unconstitutional. Laws that distinguish between different kinds of speakers present very serious First Amendment concerns. And the platforms are disseminators of speech. They're themselves disseminators of speech and are being told precisely that they cannot mute, deplatform, or deprioritize speech by specific entities, journalists, and candidates for public office. But it can do so for others. So if this isn't content-based, I mean, I don't know what is. It also appears quite viewpoint-based, based on the goals behind the law. So Florida would have to satisfy strict scrutiny here. In fact, Florida doesn't even really try that hard. They say their goal or their compelling interest is neutrality on the site to ensure a wide variety of views to reach the public. I think that's sort of laughable for Florida, who is, also regulating books and educators can teach and the content of syllabi in universities, for example. But it's also not a compelling interest in the First Amendment context. And the law is also quite over-inclusive because it covers Etsy and Pinterest. I just didn't know that there were journalists or candidates on those sites at all. So in an ironic turnaround, what Florida's doing, knowing that it's probably going to lose that speech argument, that they're going to say this is conduct, not speech. So, and therefore taking it outside the ambit of the First Amendment, what the platforms are doing are engaging in conduct. And I just want to pause here and remind where we were last year this time, arguing about the wedding site case, 303 Creative, in view of Masterpiece Cake Shop. All bakers and website designers who wanted a claim, and the court seemed perfectly willing to accept that the activity of baking and making a website was speech, and protected by the First Amendment from state anti-discrimination laws. I just don't know a world in which baking a cake can be protected as First Amendment expression, or forced to bake a cake compelled speech, and curating and designing a social media platform is not. So just as much as the government cannot interfere with the right of private parties, think book publishers, billboards, information services, news feeds, government cannot tell those folks what to do and how to disseminate. The state cannot tell a social media platform that does all of those things, publishes and broadcasts and edits and curates and refuses content on its site, what it can or cannot print. The last argument has to do with common carriers and public accommodations. So Florida is making the argument that Facebook is a common carrier or otherwise a public accommodation. So I just want to say Facebook is not the mall in Pruneyard, the California mall. It is also not the school in Rumsfeld versus Fair. Neither of those cases involved private parties making editorial choices about which speech to publish. And both cases addressed in-person access to physical property. The state may say the internet is different, and yes, the internet is totally different. But that ship has sailed, and as recently as last year with the website designer case in 303 Creative, so goes Facebook. More pointedly, I think 303 Creative held itself out as a public accommodation by stipulation, the web designer, or at least that was stipulated that it was open to all comers. Facebook does not do that. Instagram doesn't do that. Etsy certainly does not do that. They are not public accommodations or common carriers. And I'd say Florida law knows that because they are suing, or they've passed this law precisely because these platforms do make these decisions to allow some but not all conduct. So what they're trying to do is turn them into common carriers of public accommodations by force of law, but they can't do that just because you don't like how they filter content. And that otherwise that would turn the First Amendment on its head.
Okay. As a ardent, hardcore libertarian, of course, I'm going to be making a full-throated defense of free speech against government Wait, hold on. That was,
right.
That went, what, okay. How did this come about? Well, because I'm not here as a hardcore, uncompromising libertarian. I'm here as a doctrinalist. I'm trying to figure out what the doctrine says. And that turns out to be an incredibly difficult problem, but one that I think makes the arguments for these statutes marginally, and I will not say more than that, marginally stronger than the arguments for their unconstitutionality. Now, to some extent, this is one of, if we have time, two cases that we're going to do today that presents what I call the duck-rabbit problem. You've got the duck-rabbit puzzle picture. You see it as a duck. No, wait, it's a rabbit. No, it's a duck. Rabbit, duck, duck, okay? Warner Brothers fans? No, we don't have that either. Okay. Well, there are puzzle pictures that can look either like a duck or a rabbit, depending on how you see them. And because of the shambles that is Supreme Court First Amendment doctrine, there is room to look at these kinds of circumstances, and you can see, as Jessica said, the Pruneyard and Fair cases on the one hand, and you can see the old Tornillo case making clear that newspapers can't be made to publish viewpoints that they don't agree with on the other. And the question is, when you look at these large internet companies, do you see newspapers, or do you see shopping malls or law schools trying to keep out the military recruiters? Or, as Jessica said, do you see common carriers? I'll get to that in just a moment. I mean, in one sense, you can see the duck, you can see the media companies, because do these platforms exercise editorial judgment? Well, of course they do. That's why Texas and Florida passed the statutes, because they were exercising editorial judgment to shut up all my people, right? Of course they were exercising editorial judgment. And if it was a newspaper in question, this would be an easy case. People would be asking for sanctions, right, against the... Is that really, though, is it a duck? What would be the rabbit? And the rabbit in this case, as Jessica said, is the common carrier. And here we have to go back. Long before legislatures were enacting anti-discrimination laws, and by the way, that's a really recent phenomenon. I mean, you don't see states enacting anything like modern anti-discrimination laws until the 1940s, and then it's... And you don't see federal anti-discrimination laws of any consequence until the 1960s. Had some... After the Civil War, those got knocked down. They were actually quite narrow. But centuries before legislatures started doing anything, there were common law non-discrimination norms. They were why, for example, at the height of racism in the Deep South, there were Jim Crow laws, because legislatures needed to override, or thought they needed to override, certain common law non-discrimination norms. Now, those non-discrimination norms applied quite narrowly to innkeepers and common carriers. So if you were running a carriage service in 18th century England, you had to take anybody who could pay, unless they obviously had a communicable disease or were running away from the constable or some such thing. But unless you had a jolly darn good reason not to let them into your carriage, you had to let them into your carriage. Now, there's all sorts of explanation. I am not a legal historian. It's not something I've ever studied. There are legal historians who've tried to understand why it is that the common law, and this was Blackstone's got quotations about this. This is very, very basic stuff. Why would the common law have these anti-discrimination norms for common carriers and innkeepers? Just again, one little note. When Congress, after the Civil War, passes the Civil Rights Act of 1875, the thing that the Supreme Court whacked down in the civil rights cases 8 years later, what did that statute cover? Covered innkeepers, common carriers, and the one little stretch, places of public entertainment, which maybe was outside the common law core. Why were they doing this? Well, because the states were not enforcing the traditional common law norms for common carriers and innkeepers. Okay, what does any of this have to do with internet platforms? Well, if, hypothetically, the rationale for this common law rule had something to do with common carriers and innkeepers getting some kind of government privileges along the way, exercises of eminent domain in some instances on their behalf, exclusive licenses on their behalf in some instances, if that has something to do with it, there's this little thing that came along about 30 years ago called Section 230. What does that do? That gives these internet platforms an unprecedented immunity from ordinary civil liability. If one can see that as the analog to the old franchises or the old exercises of eminent domain, it's not a wild stretch. It may be a stretch. It's not a wild stretch to see the rabbit, that these are the modern equivalents of the common carriers. And in that circumstance, there's legal foundation for, again, as a matter of policy, I think it's a terrible idea. Moving to the state of Florida, and I'm going to have to hold my nose if this statute survives, right? But as a constitutional matter, not at all clear that states can't do it if you see the rabbit rather than the duck. Now, again, the parties didn't argue this quite as vigorously as I would have. As Jessica said, they emphasized the distinction between speech and conduct, that they weren't really regulating the speech of the internet platforms. Rather, they were regulating their conduct, their access rules, them standing by the door and waving people in or keeping people out, or waving people in, keeping people out, and that looks more like conduct than speech. That's not one that I'm willing to go to the mat for. But I will say this. I think the comparison to 303 is an interesting one. It was one of the cases we talked about last year. And if you actually pull up last year's records, I think what we both said is 303, that would be a really, really hard case if what the Supreme Court had to decide was whether the designer in that particular case was speaking or conducting. Now, as it happens, the Supreme Court didn't have to decide that because the state of Colorado made a boneheaded litigation decision, and they stipulated away the thing that might have won them the case. They stipulated it was all speech. If they'd actually argued speech versus conduct, we would have, I don't know that we'd like what we had, but we'd have another case that would actually bear on the one that we have. So to some extent, it may be that these cases are going to be addressing the extraordinarily difficult problem that I don't think either of us had an answer to last year. We'll see what the Supreme Court does with it this year. But if I'm defending the constitutionality of these statutes, and as I say, I do so with some reluctance, but I do so, it's because the common carrier vision screams rabbit. But if somebody sees a duck, I mean, not a lot I can say. I'm not going to spend a lot of time trying to convince people that they need a vision test.
That was a good job with the hard case. Let's do
It
Trump
is.
now.
Okay, it's that case?
Easy case.
Yeah, really easy case. All right, let me get my framer
This is your favorite case.
out here. Well,
Office and officer.
yep. Actually, it is a pretty cool case.
Yes.
All right, here's our backstory. Article 2, Section 1, Clause 2 of the United States Constitution, I have my copy here, says, quote, each state shall appoint in such manner as the legislature may direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress. Bottom line, as far as the federal Constitution is concerned, state legislatures can specify any method they want for selecting presidential electors, including the state legislature getting in a smoke-filled room and saying, okay, here's the electors. They want to do that, they can do that. From 2003 to 2016, the Colorado legislature chose to have the presidential electors chosen in caucuses. The voters in Colorado didn't like that. They did an initiative in 2016 that said, no, let's do primaries instead of caucuses. Now, it would actually be an interesting question whether the initiative process, the voters as a whole, are the legislature referred to in Article 2, Section 1. But we don't have to get into that one because the Colorado legislature, the representative body that everyone agrees would be the legislature, adopted a bunch of statutes pursuant to that initiative. So now we have a body of Colorado statutes talking about how you pick electors. And those procedures include a process for deciding who goes on to the ballot in the primaries. Okay? What Colorado law says is to be on the primary ballot, you must be, quote, a qualified candidate entitled to participate in the presidential primary election. That's the Colorado statute. Now, if Colorado had added right below that in its statutes a law saying that no one can be on the ballot for a Colorado presidential primary if the person is a schmuck, and the Colorado courts had held a trial and decided Donald Trump is a schmuck and therefore can't be on the ballot, it's not at all clear that they couldn't do that. There is a 1995 Supreme Court case that says states can't add to the qualifications of federal office, but that was term limits for representatives and members of Congress. And there is no equivalent to Article 2, Section 1 saying the state legislature can do whatever the crap it wants for the House and the Senate. So not at all clear that if they had done that, that would be a constitutional problem. But they didn't. There aren't any relevant state law provided qualifications that Donald Trump does not meet. You have to be a representative of the party, and the party has to get 20% of the vote in the last election, and the candidate has to sign a piece of paper saying, yeah, I want to be a candidate, and all of that was satisfied. But obviously there are qualifications beyond those specified in Colorado statute. If Donald Trump was 27 years old, would have been perfectly okay for the Colorado officials to say, you got to be 35. If Donald Trump was like Arnold, born in Austria, it would have been pretty clear that they could say, you got to be born in the United States, not Austria. That would be out. They didn't say any of those things. They said, well, Donald Trump is out because there's this thing that came back in 1868 in the 14th Amendment, after all that stuff about privileges or immunities and due process and equal protection and all that, there's this provision that nobody had heard of until a couple of years ago, saying, and the wording here is important, so bear with me, no person shall be a senator or representative in Congress or elector of president and vice president, or hold any office, civil or military, under the United States or under any state, who, and now here's the key part, having previously taken an oath as a member of Congress, or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state to support the Constitution, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. There is then a proviso saying the House can remove that disability if it exists by a two-thirds, of each House.
Yeah, each
House and Senate each have to, by a two-thirds vote, remove it. The Colorado Supreme Court said, yeah, that describes Donald Trump, all right? There was an insurrection on January 6th, and Donald Trump gave aid or comfort to the enemies of the United States, and out he goes. And the Supreme Court is now hearing that case. Okay, what's wrong with what the Colorado Supreme Court did? Well, just about everything. No way that under the meaning of the terms insurrection or rebellion, anything that happened in January 6th even came close, not even in the ballpark. But that's something I'm going to leave to questions. No way, even if, dressing up with horns and like weird stuff and sitting in somebody's office with no weapon is an insurrection. Donald Trump did not give aid or comfort to enemies of the United States. It doesn't say give aid or comfort to the enemies of the United States. Okay, no, come on, there's no way. Again, happy to talk about that. But the real reason why this is wrong is the reason that the Colorado lower court actually got right. And I'm going to say, this may sound odd at first glance. I was persuaded of this argument 15 years ago when it was a non-issue, period. It was a non-issue for anyone except a tiny number of constitutional textual nerd types who I happen to hang around with. And one of them, Seth Barrett Tillman, who, by the way, is one of the two most important constitutional thinkers in the world that nobody has heard of. If you haven't heard of Seth Barrett Tillman or Rob Natelson, you are missing two of the most important thinkers in constitutional law. Anyway, 15 years ago, he convinced me of something. When the Constitution talks about officer of the United States, it doesn't mean the president or the vice president or members of the Senate or members of the House. It means, and only means, offices created by statute. And the Constitution creates the presidency, the vice presidency, the House, and the Senate. Why would anybody think such a weird thing? Well, 3 provisions of the original Constitution back in 1788 use this phrase, and all of them indicate that it means exactly what Seth Barrett Tillman told me it meant 15 years ago when nobody cared. First of all, the Appointments Clause in Article 2 talks about, the appointment of officers of the United States which shall be established by law. Officers of the United States are things established by law, meaning statutes. That's why it doesn't include the President, Vice President, House, and Senate. They're not officers of the United States. Second, if you look at the impeachment clause in Article 2, the President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of blah, blah, blah. Not, by the way, President, Vice President, and all other civil offices. It's President, Vice President, and all civil officers of the United States. Why list the President and Vice? Because they're not civil officers of the United States. They're created by the Constitution, not created by statutes. By the way, the same reason why members of the House and Senate can't be impeached. They can be removed by expulsion. Doesn't happen very often, right? I mean, House is never going to expel one of its members, right? That doesn't happen, right? Okay, but they can. Senate can expel some of its members, right? But they're not subject to impeachment because they're not civil officers of the United States. They're the House and the Senate. They're constitutionally created office. They're officers. They're in the United States, but they're not officers of the United States. The killer, though, and this will show you what a nerd I am, this is the one that convinced me 15 years ago, that made it too clear for me to ignore. The Commissions Clause, the end of Article 2, Section 3. The President shall commission all the officers of the United States. Now, the President commissions justices of the peace for the District of Columbia, commissions the Secretary of State. The President does not commission the President, does not commission the Vice President, does not commission the members of the House and Senate. Why? Because they aren't freaking officers of the United States. Now, fast forward to 1868. Same language shows up in Section 3. Question number 1. Would the drafters of the 14th Amendment in 1868 actually be aware of this drafting convention? Yes, of course, these were very, very smart lawyers. There was actually an early draft of Section 3 that specifically listed the President and Vice President as being subject to it. Guess what? It didn't make it. Didn't make it through. Second, why do we really care? Well, there are 2 parts to Section 3. There are the people who are subject to the clause at all. That's the senator, representative in Congress, elector of president and vice president, or civil or military office holder under the United States. Now, question, is an office under the United States the same as an office of the United States? Probably, but I'm not actually going to be even arguing that today. I think that's right. It's possible to argue that those are 2 different things. But the real capper is okay, suppose you've got someone who's subject to Section 3 of the 14th Amendment. The person takes the 101st Airborne Division, marches into the session of Congress while they're counting the votes, kidnaps the vice president, puts an AK-47 to the vice president's head and says, certify me as the president or else. Okay, so now we've got the insurrection, okay? Now we've got the income. Now we've got everything. Donald Trump still would not be subject to Section 3 of the 14th Amendment under those circumstances. He'd be subject to all sorts of other stuff, but not disqualification under Section 3. Why not? Because the only people who are disqualified are those who have previously taken an oath as a member of Congress or as an officer of the United States, the magic phrase, or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States. Now, Donald Trump took an oath to support the Constitution of the United States, but not as any of those named officials. Took it as the president. Now, obviously you would expect anyone who eventually became president at one time or another earlier in their life to have taken an oath under one of those other positions, because they would have been in Congress, or they would have been a state legislature, or a state judge, or state something or other. Nobody's ever going to be president who's never served in any of those other positions, right? Guess what? Donald Trump never served in any of those other positions, right? He is not subject to Section 3 of the 14th Amendment. Period. End of story. Case dismissed. Okay.
Can I take it from
Yeah,
there?
absolutely.
Yeah, okay.
Go from there.
I'm just chomping at the bit. Okay. So I'm going to get to the officer argument at the end.
Okay.
Okay, I think it's worth stepping back before discussing the issues point by point and emphasize something that judges often say. Judges say this. They say, the opinion won't write. And they do that when they describe a situation in which their instinct is to decide a case one way, and then when they sit down to try to write it with all the legal arguments, they just can't reach the result that was their instinct. And this forces them to reconsider, I think, the initial conclusion. That is what is happening with this case. The more you look at the legal arguments that the president, who is an insurrectionist, cannot be made ineligible to be the president in the next election because of prepositions and cross-intertextual reading of the Constitution, the more your head just explodes. And it seems less and less plausible, I think, as you read you read Section 3 and you understand what the history behind Section 3 was after the Civil War, trying to prevent the Confederate Congress people from sitting in Congress. You understand what it's about. So fighting the plain meaning of Section 3, preventing insurrectionists, people who try to prevent the transfer of peaceful power from one president to another, turns the Section 3 inside out. It feels a little bit like when we do that with the Constitution from one text to another, like we're reading Jabberwocky, rather than a pragmatic Constitution which is meant to govern us in a democracy. And I think it means that you're getting to the wrong result. So let me just say one thing. I think that there's some interesting things that happened during the oral argument. It was argued at the beginning of this month. The fact that Trump was declared an insurrectionist by the lower court and affirmed by the upper court did not get disputed at the oral argument, and I think he is. I think the facts support that he tried to prevent the peaceful transfer of power by instructing the vice president to halt the counting of the ballots, and when that didn't work, incited a riot targeting both Pence and Speaker Pelosi that became deadly. Now, insurrection may be a broad term, and it's possible the Supreme Court will interpret it narrowly. That's fine, but either way, this was an insurrection by any measures. Everyone remembers where they were on January 6, 2021. So they went out of their way, the Supreme Court, not to touch the factual issue about whether he is an insurrectionist. What they did question was whether the trial court comported with due process, for example. That was something that Barrett was very worried about. Whether and to what extent a different trial in a different state would come to a different result, for example. And whether a single state who gets there first, like Colorado, and adjudicates the fact of insurrection and eligibility, can functionally decide the question of the presidency for everyone else. This is a question of federalism and elections. Kagan and Jackson were particularly worried about this, and Roberts. So let me say that I think the strongest argument that Colorado acted constitutionally stems from Article 2 and the state's plenary power to determine how their electors are selected, where Gary began, which implies the narrower power to enforce federal constitutional qualifications, be it age, citizenship, or whether you're an insurrectionist. States are actually quite diverse in the way they enforce federal qualifications. States have already disqualified certain people as insurrectionists from being on the ballot. Marjorie Taylor Greene was recently disqualified, but then a higher court reinstated her, for example. Madison Cawthorn was also declared an insurrectionist. There's a diversity of enforcement, and that's the function of the state power under Article 2. They do it for age, they do it for citizenship, all the time. And they do that to preserve their own electors and to avoid the disenfranchisement of their citizens. So that diversity, when states start enforcing citizenship clauses and age clauses, for example, differently, there are some people on the ballot for president who are not U.S. citizens, by the way. Secretary of States put them on the ballot anyway. It happens. That is a feature, I've said this before, it is a feature, not a bug, of our democratic federal system. The states have processes for this, and rather than saying an insurrectionist can be elected president, which is what the court might say, actually, it's better to play, because of this textual reading of the Section 3, it's better to play out state-by-state determination of their own elections. There's messiness in federalism, for sure. That's what the Electors Clause assumes will happen, and if different states come to different results, that's okay. You know what can happen? Congress can pass a law under Section 5 and fix it. That is, if it's truly federalism run amok, Section 5 of the 14th Amendment can fix that problem. So there is no debate whether states can exclude underage or foreign-born candidates. There's no debate about that. Or wannabe third-term presidents. That also came up during the oral argument. Nothing in the 14th Amendment takes away from the states their broad and plenary power to govern their own elections. Section 3 also speaks in mandatory terms. The power is plenary unless something in the Constitution tells the state can't do it. Like the first section of the 14th Amendment, no state shall. That takes state power away from the states. Section 3 does not take power away from the states. So the other side is going to say, Gary didn't say this, but at the oral argument, that Section 3 has never, actually you did say this, Section 3 has never been used this way. Like no one had thought about it before. And I just want to say, January 6th was unprecedented since the Civil War, and perhaps this is exactly what Section 3 is for. Hopefully the exceedingly rare times an insurrectionist is frighteningly close to capturing the seat of national power and commanding our armed forces. That's precisely when you want Section 3 to work, not when it gets stripped of its power. So as I said, Congress can fix it if it wants. Congress can remove the disability with a 2/3 vote. They can do that right now. Congress can act if it wants to. It can pass enforcement legislation to preempt other states from doing this. We are not out of options. We certainly don't need the Supreme Court to put a thumb on the scale of presidential elections again. Remember that? Okay. As to the argument that Section 3 wasn't meant for the presidency, that is where Gary, his wonderful nerdy textualism is, either because of the history of the drafting, or a bit more quirkily because the president is not an officer of the United States, as that term is used throughout the Constitution. I just want to repeat what I said at the beginning, which that opinion does not write. There is just no possible rationale for such an exemption. And to suggest it's because, that's just what the text says, and that's the best way to render the Constitution intertextually harmonious, sort of a too bad, so sad kind of way, I think means we're admitting that the drafters made a mistake, an extraordinary mistake, actually, but I don't think they made a mistake. Section 3 uses deliberately broad language to cover all positions of federal power requiring an oath to the Constitution. The claimed differences between an office of and an office under is a distinction without a difference, I would argue, because I don't think the Constitution is a poem. It's not a poem where each exact work is precisely, purposefully distinct with meaning, and especially not so deliberately crafted after a civil war, when the folks who were writing it after the Civil War were not the same people writing it in 1789. The case should not come down to prepositions, I don't think. The two phrases, office under and office of, are really two sides of the same coin, referring to the federal office or anyone who holds an office. just think, why would you exclude the president from disqualification when the disqualification is insurrection against the United States? It makes no sense at all. That's the best thing.
Okay, not bad.
So we are,
I know, we are.
we're there.
Are we there?
Oh,
We're there, but
I'm
a
okay
couple of
with that.
things.
yeah? We
We
have
have two more cases that we were hoping to get to. Jarkizi is one that I'm really interested in personally, but we can talk after. To me, Jarkizi might just be another Chevron case in a way. It's a Chevron case, anyway.
Okay. Oh, and we have the redistricting case.
And the redistricting case, but I kind of want to I had said fill out questions. Does anybody have a question that they would like to ask about the three cases that we've talked about?
Or we could talk about the
talk a little
SEC.
bit.
We could talk
or the-
after.
or the-
We could do a
the
quickie.
redistricting.
Could you do,
Version of Jarkizi.
let's do a
Let me do a-
flash,
let me do a real-
a lightning round
You do
on.
a lightning
Let me do a
round?
lightning round.
And I'll do a
on-
lightning
on-
round on the
on-
NAACP.
On Jarkizi.
Yeah.
Okay, 1934, Congress creates the Securities and Exchange Commission. Along with the 1933 Act, there's a whole bunch of provisions in there, making all sorts of things that look a lot like fraud, federal matters. And in 1934, the SEC can march into federal court and bring suit against people. Fast forward 60 years, in 1990, Congress authorizes the SEC to impose civil penalties against certain people, but to litigate those before its own adjudicators, administrative law judges who are not Article III judges. 20 years later, in 2010, that's extended to anybody and everybody, and that is used to go after Jarkizi for all sorts of things that, if proven, are pretty bad stuff. Let's not mince words here. The SEC says I can go into court and prosecute this person for fraud, or I can do it before our ALJs. If I go to court, our win rate's about 60%. If I do it before our ALJs, gosh, our win rate seems to be 100%. I wonder why we do so well. So they do it all in-house. $300,000 in fines, $685,000 engorgement, and basically the death penalty as a professional investment advisor. Okay. Throughout this process, Jarkizi is saying, well, there's a big problem here. The SEC is imposing all of these monetary fines on me, but this person's not a judge. I'm not getting a jury. There's no jury in the SEC's adjudications. And by the way, this adjudicator can't be removed by the SEC, or for that matter, the president, unless there are certain specified causes. And the SEC commissioners can't be removed by the president without certain specified causes. And didn't the Supreme Court in 2010 say you can't do that? You can have certain officers not removable by the president, but that if they have the power to remove someone else, those someone else's can't have only for cause removal. And all that's argued before the SEC and then in the lower courts and dismissed on jurisdictional grounds. And a decade later, this all comes to the Supreme Court, and that's where we are. And three arguments, all resolved in favor of Jarkizi in the Fifth Circuit Court of Appeals. One is what the SEC is doing here is essentially a suit at common law, asking for money damages, fines for fraud, and under the Seventh Amendment, since $300,000 is more than $20, you need a jury. Second argument, the double for-cause removal thing. Supreme Court has been steadily over the last few decades limiting the extent to which Congress can insulate executive officials from presidential removal, to the point where what we now have is, I would describe, an ocean of presidential removability power with a few pieces of driftwood where Congress can limit it, and this doesn't fit the driftwood, says Jarkizi, because it's the two-level removal thing. And the question is whether, because these are adjudicative officials, that makes a difference. There was also a throwaway non-delegation argument that the Fifth Circuit bought that nobody's arguing about in this case, so we're not going to deal with that. Okay, That's the setup. I mean, do we want to talk about the issues?
And what
or we
did
just
he
do
get,
setup?
by the way? He got fined $1 million.
Yeah, it's
and,
like
and was-
$985,000.
And he got the career death
And
penalty.
the death penalty, yes.
Right. So
No
without seeing a judge.
No, without seeing, well, they're
An
not even
ALA
arguing.
judge.
Right,
He
he's
saw an
not the
ALJ.
ALJ, he didn't see an Article 3
That's what I was
judge,
gonna
but
say.
they're
He
not
did see
actually
it.
arguing that, they're arguing he didn't get a jury.
Yeah.
Right,
yeah.
that's correct.
Right.
Right. Bankruptcy judges, magistrate judges, and
Yeah.
ALJs.
Okay.
Yeah, now you know why I'm interested.
Yeah.
Yeah, yes. Now,
I'm-
truth be told, I wanted to file an amicus brief on the 7th Amendment issue. I wrote it, it's really good, and the DC lawyers who filed the brief completely rewrote it, so that what actually got filed had nothing to do with anything that I wrote. Okay.
The court was very interested in the Seventh Amendment.
Yes.
We did
Our argument was all about the 7th Amendment.
We did file a brief in the case, by the way. And
Right. So I have arguments against that. I will not say that. What I will do is quickly set up the last case, which is a racial gerrymandering case called Alexander versus South Carolina State Conference of the NAACP, and I'll just set it up. And then we can talk about questions. So the case is about whether a Republican-controlled South Carolina legislature deliberately considered race when drawing new congressional district maps in the after the 2020 census. So in January 2023, a 3-judge panel sided with the plaintiffs, ruling that the legislature had purposefully moved thousands of black voters from one district, District 1, which include Charleston, into District 6, which was represented by James Clyburn, and it's a predominantly Democratic district. So District 1, where the black voters were moved out, had been reliably Republican for all but 2 years since 1981. And the argument that defendants made was that they were just trying to keep it that way. But in 2018, Democrat Joe Cunningham flipped the district from Republican to Democrat, and then lost re-election in 2022 after the redistricting to Nancy Mace by a very, very close margin. And the new maps in 2020 was meant to make that next race in 2022 less close, and in 2022, in fact, they were less close. So as a racial gerrymandering case, it's not brought under the VRA, it's brought under the Equal Protection Clause. And the issue was that the maps intentionally selected black voters and the lines were based on race. So what's interesting about this case is it's the first case the Supreme Court is taking trying to combine or disentangle partisan gerrymandering from racial gerrymandering. Only the latter is unconstitutional. So that's Rucho versus Common Cause in 2016. So you can partisan gerrymandering all you want. You can say, I just want a Republican district and that's all I'm doing, and that's not unconstitutional. But if you use race to do that, it becomes unconstitutional, or at least subject to strict scrutiny. So this is the first case that the court appears to be wrestling with. Can you hide a racial gerrymandering over a partisan gerrymander? So how do you determine whether race predominated, for example? How do you know that when they keep saying it was just about a party, not about race? It's also the first case that the court is hearing in which computer models were used to litigate and to prove racial purpose. So this is where the algorithms come in and all the different ways they can model it. That was part of the evidence. And lastly, it's the first case since Gamillion versus Lightfoot in 1960 when only evidence of racial motivation is circumstantial. It's all circumstantial evidence, and the court was really wrestling with whether direct evidence or some alternative form of evidence should be required. It's going to be clear error on review. The court takes it as clear error. The district court below found striking evidence of racial gerrymander. So whether the court is going to take the clear error standard seriously or whether it's going to second guess the experts, for example, and the testimony, the unreliability determinations by the judge is what's at issue in that case.
That's the other duck-rabbit case. Politics, race, duck, rabbit, duck, rabbit.
Sorry for running out of time.
No,
Yeah.
it's, you
No.
know, and these cases, I mean, they are tectonic plates this year, I think.
It is.
You know, these things
Right.
are shifting, and maybe they aren't. Last year, we thought some were going to be, and they,
Yeah.
not necessarily, but they sure look like it. A little aside on Jarchese, I say, but Jarchese. Yeah,
They say Jarchese.
Jarchese.
The oral
Jarchese.
argument, they said it's
Jarchese.
I pronounced it Jarchese
He
my
said
whole
it,
life,
sure.
and then an oral argument said, well, it's a Jarchese.
So our team helped prepare for that argument with and Mr. Jarchese wanted his lawyer, and believe me, they were lined up, you know, the big bar in Washington to take over that case, but he wanted the guy that won that case for him, you know, at the Fifth Circuit, which I understood. But the sense among the team was, uh-oh, you know, he's really not ready for this. And I thought they loved him, and I thought he did a great job. Did you listen to the argument?
Yeah.
Oh, yeah.
I thought he did okay.
Just okay.
Yeah, I mean, they're predisposed to his argument. The majority of the court is predisposed to the Seventh Amendment argument,
So
for
you're
sure.
ready to say,
They're gonna
gonna-
hold that it's the same. It's a common law fraud. That what he's been charged with is common law fraud. It's analogous to that. It's not a public right, and it has to be. That's what they're gonna say.
I thought a great question was, if this were a criminal matter, he'd get a jury, right? And his exposure in a criminal matter, $1 million fine?
Yeah.
I mean, you know,
Yeah,
that I
right.
thought was
So,
a
but
good
that's where
question.
the Article 3 question and the Seventh Amendment question intertwine. So, which comes first? If the SEC was properly given power to adjudicate these claims under as a separation of powers matter, why can't they adjudicate the claims through their agency? The question is, I mean, so it's an order of operations problem in terms of the Seventh Amendment, and you could hear the justices asking, like, do we start with the Seventh Amendment? Do we start with Article 3? And I think they're gonna start with the Seventh Amendment.
It seemed like it. Anyway, thank you so much for everything. It really was. This is a deep dive, believe me. And thank you all for coming. And the bar's open.